Thank you for joining us for this episode of the Immigration ABC's podcast. I'm your host, Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. Today we're sitting down with my colleague, John Barrera, to shed light on a topic that's especially relevant to U.S. immigration today, and that's been in the news a lot in recent months. And that's how criminal law and immigration law interact. We'll get into how even minor interactions with law enforcement can impact immigration status, what to do if you're stopped by police, and how to put your best foot forward if you have a criminal history and are seeking an immigration benefit. John's the perfect person to have this conversation with. He's an immigration attorney with over 20 years of experience focusing on removal and deportation defense, humanitarian immigration, and family-based immigration. He has represented thousands of clients in immigration courts across the United States, including in complex cases involving the intersection of immigration and criminal law. And he successfully helped clients terminate deportation cases or obtain relief that allows them to stay in the U.S. John has also secured approvals in asylum, U-Visa, and VAWA cases, and he's handled employment-based and family-based petitions before USCIS. John, thank you so much for being here, and welcome to the show.
Thank you, Dustin. It's a pleasure being here, and thank you for the opportunity.
So, John, to start, why don't you tell us a bit about what first drew you to immigration law?
Yep. It started with my family. I was born and raised in New York, in a town that has a large Hispanic community. So, watching family, friends, having to go through the immigration process, sometimes going with them to visit immigration attorneys, kind of started that itch. And it was curiosity at first, then concern, where you observed how, their lives were at risk because, they didn't have the proper paperwork. Maybe they were at risk of being removed. And then wanting to understand, how that process works. And then that turned into, I want to help. I want to try to help, people in that community. And then, in the general immigrant community, to try to, I've always been a believer in the American dream, going through my schooling and everything. So those two kind of concepts started to coincide, that right to live that American dream, the story of immigrants coming to the U.S., and then living kind of living through that with family and friends, their ability. So all those things kind of coalesced into one kind of desire, to try to pursue this career.
Perfect. So, John, have you ever held a position that's specific to criminal law, whether that's, for example, criminal defense or prosecution, anything like that?
Yeah. I started my career. I worked at a public defender's office out west in Idaho. I did that for a few years. It was a very aggressive office. We would take a lot of cases to trial. If we, we were very proud of that fact. We just wouldn't roll over, and we would take and we had a high success rate. So, working with that office, my Spanish speaking abilities, then I started, dealing with more Hispanic clients, especially a firm out west. And then, again, kind of like that desire that I had to work immigration law, those two things kind of coalesced at the same time. That ability to speak Spanish, immigrants, seeking, my guidance with criminal cases. But then as we're going to start discussing, kind of like that intersection of immigration and criminal law starts to come into play. So I was kind of, I was kind of forced into learning it, but it wasn't kind of like a situation where I was kind of like not wanting to do it. I was kind of excited about that opportunity as well. So it kind of worked out in that sense.
Mm-hmm. And you mentioned the intersection of criminal law and immigration law. So, of course, we have criminal defense attorneys and we have immigration attorneys. Many people practice in those two worlds separately. In your own words, why do you think it's so important to be familiar with both of those areas of law, criminal law and immigration?
Yeah, especially in recent years with the policies of the current administration and how how aggressive they've been in the sense that they're now using the U.S. immigration system, more specifically Department of Homeland Security, to be another enforcement arm for the U.S. government. So that, with the fact that there are immigration laws on the books that talk about disqualifying a foreigner from an immigration benefit or taking away an immigration status from a foreigner that's living here legally, right? So just the basic fact that there are laws that deal with that. I mean, that that to start to understand that intersection between immigration and criminal law.
Perfect. And so let's actually get into some of the substantive aspects of your practice. So you mentioned these significant consequences that can happen as a result of interactions with law enforcement. What kinds of interactions with law enforcement can possibly affect a person's immigration status?
I think the rule of thumb is an arrest. If the non-citizen has been arrested, you're probably going down a path of a dangerous path where potentially you could be exposing yourself to, if having a status, losing the status. And in the situation where if you're not here with legal status, then potentially being placed in removal proceedings. So the arrest is kind of like that rule of thumb, that almost certain situation where you're going to be at risk at some point. Obviously, you have other law enforcement encounters. There could be those are kind of like, a case by case situation. What does that encounter lead to? If there's no investigation, it was just kind of like a conversation, like maybe what we see or hear sometimes in TV or anything like that, where a cop just comes up and who are you? What's your name? Identify yourself. And it doesn't lead to anything else, that's not going to be a problem, right? Now, if the encounter leads where the officer will cause to detain, arrest, search, and they find maybe drugs, that's going to lead to an arrest. So that's again, that goes down that path of danger where potentially you could be at risk of being of losing your status or maybe being removed from the U.S.
So to take an example, a simple traffic stop, say speeding or driving without a headlight or possibly suspicion of a DUI, driving under the influence. Are these examples of interactions that can have an impact on immigration status or one's ability to apply for an immigration benefit?
And again, it's a case by case basis, right? So I'll try to give you 2 or 3 scenarios. So you have a non-citizen here. He has his legal status. He was just pulled over for maybe running a stop sign, right? That's all it was. Just leads to a citation, nothing more. That's probably not going to be much of anything in the future. Now, you might have to be aware of disclosure issues, like if you're renewing a visa or extending a status, in most cases you have to reveal any kind of law enforcement encounters. That's where you maybe have to worry about even a minor encounter with a law enforcement officer. You don't want to annoy the officer that's reviewing, your immigration officer who's reviewing your case, thinking you're not wanting to disclose something for some, you're hiding something, right? Then you have more precarious encounters, like the DUI that you mentioned. Yes, that'll lead to an arrest, more than likely. And then DUIs are kind of like this, they have kind of like their own kind of world, because, you have criminal offenses, like let's say you got pulled over and something led to the officer searching your car and they found drugs in your possession. So the drugs, that's a problem because that could disqualify you from an immigration benefit. That could potentially lead to taking the immigration away from you just because you committed that crime of possessing a drug. DUIs are a little bit different because on the books, they don't disqualify you from an immigration benefit. They don't make you deportable where they can take the benefit away because you got convicted of a DUI. However, when you're talking about someone who's here temporarily, so they have a temporary legal status, immigration takes a very aggressive stance with DUIs because they have the ability to revoke your visa potentially because of a DUI related arrest. So it's not kind of like a legal consequence where you violated an immigration law because you got arrested for a DUI. It's almost discretionary, although there are regulations that talk about this, where they have the immigration has a right to revoke your visa just because of the DUI arrest. It's almost like you're a danger to the community. There's also a health potential issue that they might put on there because they think you have problems with alcohol. So that's kind of like that hybrid kind of situation where they could justify taking away that visa. Now, to be clear, now if you have the person who is trying to apply for an immigration benefit, like let's say they're trying to apply for a green card, they're not disqualified. So if they try to apply, they have a drug conviction, they're disqualified. Now we have to talk about potential waivers, but they're technically disqualified if they don't meet waiver criteria. Not the same thing with DUIs; they're not disqualified. Now, potentially they could face other problems. Again, that health-related inadmissibility issue, where okay, this problem has a problem with drinking, alcoholism, and stuff like that. They could potentially deny because of kind of like that indirect consequence of the DUI, but not because you committed a DUI. So there's that kind of like, it's a case by case, right? Are you at risk of losing your status? You're here, you're at risk of losing your status. Although a DUI doesn't, make you in and of itself deportable or disqualify you, it can lead to a revocation. Are you trying to get an immigration status and you have a DUI in your past? It doesn't disqualify you. You're still eligible, although they can try to make it hard for you based on discretion. They think that you have health issues, you're an alcoholic and stuff like that. So kind of like indirect consequence could happen, and you'd have to deal with it that way. So it gets very complex, and again, you have to kind of treat it on a case by case basis. Now, if you have someone who had a DUI 10 years ago, probably not going to be a problem, especially for that person trying to get the green card or even trying to apply for a non-immigrant visa, right? Because it's in the past, it's been maybe taken care of, not really an issue anymore. It's more so like the more recent DUI. So the last maybe couple of years, they got a DUI and they're applying for a status. You might get some resistance from the government in trying to get that status, whether it's a green card or a non-immigrant visa.
And hearing you talk about this, you've mentioned case by case several times, and it's becoming, I think it's clear why each of these is a case by case situation. Because when someone comes to you, you have to look at what actually happened. What was it? Were you just stopped by the police? Were you actually arrested? Also, you have to look at what exactly were you charged with. And DUI versus drug possession versus running a stop sign. These all can have completely different and dramatically different consequences. I think a couple of the takeaways, first of all, I think you make it very clear why working with an attorney who understands how to navigate these complexities is important. But I think the other takeaway is the impact of being arrested can affect so many different aspects of someone's immigration status or their ability to apply for a benefit, whether that is to apply for a visa or to apply for a green card, or to affect their ability to even enter the U.S. Is Customs and Border Protection going to screen them and see this pop up and give them issues at the border? So I think I think those are some of the big takeaways that I'm hearing from what you're saying. Something that I know comes up quite often is people assuming that something that happened in their past, maybe they have a charge, maybe they have an arrest, but it was dismissed or the record was sealed, or they were a juvenile. So therefore, it doesn't matter anymore. Can you talk about that? Does it still matter? What is the effect of a juvenile conviction or something that was sealed, what's the effect of that? Does it actually disappear? Does it need to be disclosed? Curious to hear your thoughts on that.
Yeah, and this goes again with kind of like this theme that's kind of being created in our conversation where things aren't really what they seem to be in this intersection with criminal and immigration law. Again, I use the term case by case basis. What exactly happened? You use the word, that word can different jurisdictions for starters. Then you have to look at, okay, why was it dismissed? Was it a case that went to trial and the dismissal was an acquittal where a jury found the person innocent? Was it a situation where there wasn't sufficient evidence, the judge dismissed the case because of lack of evidence? Or maybe the prosecutor dismissed it sort of for the same reason, not enough evidence to justify the pursuing of the charge. So you have those kind of dismissals. So where there's no guilt, there was no finding of guilt, it was an outright dismissal. Then you have other kind of dismissals. A lot of jurisdictions use the word dismissal in a situation where the non-citizen actually pled guilty or was convicted of a crime. But then because of good behavior, they complied with probationary terms. They were, an exemplary, probation candidate. They file a motion with the criminal judge, and the judge dismisses it because of good conduct. And so then there's an annotation in that court system or the criminal justice system noting that there was a dismissal in the case. I think it's fair to say those are the two type of dismissals you're going to be dealing with when you're working these type of cases. So then you have to look at, okay, so how does immigration look at these dismissals? So when they look at a dismissal because you outright won your case, prosecutor dismissed, judge dismissed, or you won a trial, immigration respects that. That's not considered a conviction. So you're not free and clear yet because it depends also what were you charged with as well. Because there are certain crimes are called crimes involving moral turpitude. What is a crime involving moral turpitude? You got to look at that because it's not clearly defined. So you have to deal with that because if you won your case at this because it was dismissed, you're probably going to be okay because I don't believe they can go beyond that. Immigration go beyond that to try to ascertain whether you committed a crime or not. It's a situation where perhaps there were no charges brought. Maybe there was lack of evidence, so there was no real formal proceeding. And then it's kind of still out there with the immigration world, where the immigration officer could maybe try to elicit an admission from you at an interview. That could be damaging, especially if it's a crime involving moral turpitude, to disqualify you from the process. So I went on a tangent there for a little bit, but that's what you're dealing with those kind of cases where I mentioned dismissal, but then you have the cases where maybe they were never brought, the charges were brought, but the immigration officer became aware of a potential crime and tried to elicit an admission. So the immigration attorney has to kind of be aware of all these potential factors to guide the client, as far as, do I pursue my benefit or, creating strategy on how we're going to pursue it, how you're going to deal with an interview. Then going back on track, the dismissal based on good conduct. There was a conviction, though. So immigration does not really recognize that. Even though a criminal judge maybe annotates that it was dismissed, for immigration purposes, they're still going to consider it a conviction. And you have to deal with it in that way. Now, that subsequent dismissal helps progression. So if case where it disqualifies you, but you could apply for a waiver to have immigration forgiven and still move forward with the benefit, it's a positive check mark on your record, right? It's something that shows that you did something to try to show that you're a good person. You made a mistake and you tried to overcome that benefit that the criminal judge gave you. You can use it in that sense. But if you're going to argue that, I was never convicted for this, no, immigration is not going to take that argument at all.
And having spoken with you over the years, two things that I just want to quickly add that you've brought to my attention. One is, and you mentioned this, even if say you were arrested, say it was dismissed, no problem, if you're then at your interview at the consulate and you tell the consular officer, yeah, I did A, B, and C, that you actually did the things that would have led to a conviction, that's the same. You can still get hit with that in an immigration perspective. And I think the other thing is when it comes to, are these things you should disclose or not disclose? Two quick thoughts on that are, first of all, you should definitely tell your attorney because you need an attorney with whom you have attorney-client privilege to guide you through how best to frame this in your application. But the second thing is, as a general principle, when it comes to this kind of thing in visa applications, being transparent in general, my understanding, and John, I do want to hear, of course, your thoughts on this. In general, transparency is important here. That if there's something in your past that was sealed, for example, you probably want to disclose that in an application and explain it was sealed and explain, in the years since there's been rehabilitation, whatever. That is usually a better option than not disclosing it, them finding out, and then you potentially being hit with not only a denial, but also a misrepresentation claim at your interview. But John, I'm curious to hear your thoughts on that.
No, I completely agree. It's you're going to err on the side of transparency in these cases. Disclose something. It's got to be something where it's clear that there is no record of it. And I think I'm alluding more to that situation where maybe you had an encounter at night with an officer who asked you for ID. And what you look at also is what are you applying for? What are you being asked? Okay, so if the question is asking you about only arrests and convictions, you probably don't have to disclose any kind of all encounters, or kind of like that encounter where you're just being questioned for a short period of time. But if you were arrested, even if it was by mistake and they release you 5 minutes later, you probably need to disclose that, but you explain it, just like you said. You explain what happened, what was the misunderstanding. Most often, again, the value of the attorney, right? We're going to help you explain that situation where it's not going to be a problem, where there's not a misunderstanding. But what you don't want is not disclose. They find the arrest, and then they hit you with the arrest at the interview, and then you're kind of in that uncomfortable situation, especially if you're kind of nervous, trying to explain to an angry or annoyed officer what happened. So you're going up that hill, right? You're going up that hill instead of maybe going downhill if you disclosed from the beginning.
Perfect. So I'd like to switch gears a little bit, and kind of not give you a hypo, but really kind of walk through. We read the news. It's clear that the government has a very aggressive approach where there are a number of agreements, say, between ICE and local law enforcement agencies around the country. Let's say that someone calls you and says, hey, I was just arrested, DUI, let's take that example. I'm here at the police station. Let's say they have a visa. What is your thought process in terms of the practical steps they should take in that moment to kind of mitigate risk to their immigration status?
Yeah, it's kind of tough in that scenario to mitigate because you're in a situation with DUIs where you're dealing with driver's license suspension issues based on the administrative side of things from the Department of Transportation from your locality, as well as the criminal issues. So, it's easy to say, sort of like in other criminal situations, don't say anything, don't admit to anything, don't cooperate, because you don't want to create evidence for, the prosecutor to later come after you in the prosecution. But the problem is if you don't comply, you're going to be hit with pretty significant driver's license suspension automatically, just because you're not taking what they call those field sobriety tests, if that's what you're looking at. So you could be looking at least a year, maybe even more, of a driver's license suspension, and that could be pretty difficult for most people, especially if they live in an area where driving is the only way they could get around. So you're dealing with that situation. So again, case by case, what's the priority for the client? Obviously, if the priority for the client is to, avoid that conviction, perhaps you don't cooperate with the field sobriety test, but get ready to deal with the consequences of the license suspension. And then you go from there, because these processes are very technified now for DUIs. So, they could, the officer could still try and testify at trial based on what he's observed, driving patterns and stuff like that. So it's not a cut. You kind of, what the attorney has to do is try to guide and explain the consequences of certain decisions to the client as best as possible. And then the client has to make that decision. What am I going to do? Because you have jail time, you have driver's license suspensions. When you get your driving privileges back, you got interlock devices, and then you have the immigration consequences that are coming after you. So it's kind of like trying to explain all those things to the client, and then the client tells you, okay, this is what I want to try and do. I don't want to go to jail. I don't want to. Then, okay, what does the evidence look like? Did they run the field sobriety test correctly? A whole gambit of stuff that you kind of have to deal with and see, how can you get the client out of this? But the bottom line is that it's difficult. I mean, once you get arrested for a DUI nowadays, it's a very technified process. And the other problem is that most often the client is not going to know of you until after the problem. So he's probably already gone through the field sobriety test. He's already blown on the machine, the intoxilizer. So they already probably have him. So it's a question of, was there a problem with the investigation, with the machine? I look at the blood alcohol content when he was, can I argue that perhaps he wasn't at the blood alcohol content level 0.08 when he was arrested, but because they have to wait 15 minutes before they administer the blow, that's when the BAC rose. So you have that argument as well. So those are the things you kind of look at to see if it's worth taking to jury trial and trying to beat it that way. But my understanding is that's not even full. Even if you could beat the DUI, you still may have to deal with revocation issues with the Department of State and stuff like that. So it's not a foolproof thing. So the DUI, it's a hard situation to deal with a non-citizen.
So let's take a step back from the DUI and broaden it and talk just about sentencing. How would you say that an immigration lawyer and a criminal defense lawyer think differently when it comes to plea deals and sentencing? Are there things that an immigration lawyer is going to think about and keep in mind that, say, a criminal defense lawyer typically wouldn't when it comes to that?
Yes, potentially yes, because the criminal defense attorney, if he can't get the case dismissed or he doesn't think that the case has a viable chance of winning that trial, is trying to mitigate consequences. So they could potentially be looking to, this is probably more apparent in felony level offenses, violent felony level offenses. Where I think a default for many criminal defense attorneys is let me try and get this down to a misdemeanor, right? So an assault, a felony assault, aggravated assault, where you want to get it down to a misdemeanor, looks better on your record. You even have maybe the potential of this is a tricky part, where you can maybe get the judge to not even give any jail time, but you get a suspended sentence. This is where it gets tricky. So where the judge maybe gives you a sentence of 1 year of jail, but he suspends that time. So what does the client observe? The client, what he observed or what she observes is, I didn't do any jail time. My attorney did a fantastic job, right? Not so much in the immigration world, because let's take that scenario again. You got a felony assault case. you're potentially dealing with years of prison time, right? If you get convicted, the attorney did a great job, pled it down to a misdemeanor, 1 year suspended sentence, but he never steps into jail. For immigration purposes, they don't look at how much time you actually served in jail. They look at the suspended sentence. So then you're dealing with the situation with the type of crime that's called an aggravated felony. And in the assault context, there are different forms of aggravated felonies, but when you're dealing with the assault context, it's a crime of violence. So a crime of violence with a 1 year sentence or more is considered an aggravated felony. And that's going to really hurt you if you're trying to get an immigration benefit, especially if you have an immigration benefit. This is severe for green card holders because there are crimes that a green card holder can commit that could put their green card in jeopardy, but they could fight for a waiver or forgiveness before the immigration judge. If they get convicted of an aggravated felony and they're thinking, oh, a misdemeanor assault, didn't do any jail time, I'm good to go. ICE is coming to get you, and because your immigration world is now an aggravated felony, not criminal world. You got a misdemeanor assault charge, but you got an aggravated felony in immigration world because it's a crime of violence with a 1 year sentence. You can't fight for the waiver; you're disqualified. So that's a significant contrast because you're of criminal. I mean, it's not good to have a criminal record, period, but from a felony down to a misdemeanor assault, you had a great day. That's a great deal. But not so in an immigration world, your life could still be significantly impacted because now you face detention and then potentially removal with no real way to fight the case because you've been disqualified because of the level of offense under immigration law.
Wow, that's a great example. Really does clarify the distinction between the two. You mentioned waivers. The last question I want to ask you before we start wrapping up is, when you mentioned waivers, you made me think of this. So let's say someone, they have a criminal history. It was years ago, and they've worked hard to turn their life around, and now they're looking to apply for a visa. What should they know about in terms of how to put their best foot forward, how to increase their chances of being approved for whatever benefit they're applying for? Let's assume it's a visa, given that they do have this criminal history.
Certainly. Again, you need to understand, did this crime create an issue of inadmissibility or disqualification from the visa? If that's the situation, so you're looking at, potentially a crime involving moral turpitude. Those are crimes usually where there's some sort of like a fraud or a high level of violence. A vulnerable victim was involved. Those are generally the gambits of those crimes involving moral turpitude. Was it an aggravated felony? Was it a controlled substance offense, a drug offense? Those are the type of crimes that typically will require a waiver. So basically, hopefully you speak to an immigration attorney and he's going to prepare you to ask for that waiver when you're going to the interview at the consulate. You're basically, there are certain factors that you have to meet, but generally speaking, what you will need to show, this was just, hopefully it was a one-time event or something that happened many years ago. Like you said, you're showing rehabilitation. You're not going to be a danger to the community or the interests of the United States. That's kind of like what you're trying to show to the consular, well, not the consular officer. You're making the request to the consular officer. Consular officer has to go to the back office, essentially to his leaders, to get them to look at the waiver and then potentially approve it to overcome that inadmissibility and hopefully get approval for that waiver. If it's not an inadmissible offense, okay, so what was it, right? So we keep talking about DUIs. That's a problematic charge. So how recent was it? So remember we talked about if it was 10 years ago, probably not going to be too much of a problem. You're probably going to be fine. So you're not disqualified. It's an old conviction. You'll probably be fine. Happened last year or maybe 2 years ago. That gets a little bit dicey. because the consulate may require you to go through some sort of rehabilitation, an additional form of rehabilitation, a medical exam in order to get kind of like that final clearance. So it's not, it's kind of like a waiver, but not really. It's kind of like a clearance to be able to get that visa, because you're not, I believe it's under a health risk. You're not a health risk because of you're potentially an alcoholic somewhere. It's something like that. So you have to, so that's what you have to know. Are we dealing with inadmissibility? Is it and mostly I think these cases arise in DUIs, drugs as well. They could look at it sort of like a DUI case, but it's on the books. Drugs are on the books, so you could be disqualified. So you might have to seek a waiver because of a drug offense as well. So you kind of have to look at what the offense is. Fortunately for most crimes, almost all crimes, I would say, you're probably in the game to get at least a waiver or qualify for a waiver if you're trying to get a non-immigrant visa, so a temporary visa. When you're looking for a green card, that's a different kind of, that it starts to change because now we talked about aggravated felonies. When they're trying to take your green card away, you could, funny enough, when you're trying to apply for the green card, you're in play. You could get a waiver for an aggravated felony. But then you have the drug charges. If you get a drug charge, depending on how it was worded, and, but let's say it was like for possession of cocaine, you're probably not going to get, there's no waiver for that.
When
but
you
have
about
to,
a green card.
For a green card, right?
Yep.
Not the temporary visa.
Yep.
But we have to look at it, because sometimes when the person got the conviction, especially if it was in the U.S. and they had an attorney who knew about the intersection of criminal and immigration law, sometimes you could play out let's say you get an aggressive prosecutor, but sometimes you could get a plea deal where it's not really clear what you were convicted of. So it's a controlled substance offense, but it's not clear what you were convicted of. And then sometimes the state statute has a list of drugs that are illegal, but they don't match the federal list of drugs. And sometimes you could finagle something, it's kind of like a legal loophole where you could maybe still be in the game to still qualify for a benefit. It's a very tight loophole, but sometimes it works that way. But trying to give you examples how potentially you could deal with these different type of criminal issues when you're dealing, even because sometimes you think all is lost, all hope is lost. Speak to the immigration attorney.
Yeah.
Sometimes we could find a way around it.
No, that's a great takeaway. I still remember when I first realized that for a temporary visa, there's basically no crime that you cannot request a waiver for. And that is a powerful thing to know, right? And it
Absolutely.
Also is it's also kind of a to me, it should be a source of encouragement for people, where what a waiver is saying, as John mentioned, is it's not only going over your criminal history, it's looking at your rehabilitation. What steps have you taken to turn your life around, and what's the benefit you look to bring to the U.S.? And if that's where your perspective is rehabilitating, bringing a benefit to the U.S., then there's a reason for hope, I would say, there in the temporary visa context. In the green card, as John mentioned, it could be much harder, but I think that's a really helpful takeaway, especially in the non-immigrant temporary visa context. Well, John, this has been extremely informative. I want to ask you one last question before we wrap up, and that is, do you have any final words for our audience, whether that's something you think they should keep in mind about this intersection between criminal law and immigration law, or really anything else?
Sure. Maybe I already mentioned this, but I think what's important to keep in mind is that it's a very complicated issue. It's not easy to figure out on your own. A lot of attorneys don't fully understand it either. So if you're facing a situation where it looks like you're going to have a problem, whether they're going to take your status away or you're applying for an immigration benefit, I think it's pretty critical. You need to speak to an experienced immigration attorney who knows how to deal with this intersection with criminal and immigration law. Even if it's bad news, that the attorney is going to give you, it you're going to be educated and you're going to understand the whys, and then you're going to make your life decisions based on that. You're not going to be basing decisions on false hope, in other words. Or the attorney could come up with a solution, and many times we can come up with solutions in these cases. But that's what you need to educate yourself. You need to get the proper advice in order to make that decision. Am I going to pull the trigger to try to get this benefit, or to try to stay in the United States? Or maybe I have to make a hard decision, but it is what it is. At least I know what I'm dealing with. I think that's the biggest piece of advice. We're not miracle workers, obviously, but we're advocates, we're guides. And that's what people should try to lean on us for, so they can make that proper decision.
Great closing words. Thank you so much, John. Thank you for taking the time and sharing your expertise. To our audience, thank you so much for listening. Please subscribe, leave a review, and of course, share this podcast with anyone you know who might be thinking about coming to the United States. We'd be happy to help. Everyone stay well. Thanks so much. Bye.